to recognize the ranking member of the Subcommittee on the Constitution and Civil Justice, the gentleman from Tennessee, Mr. Cohen, for his opening statement.
Thank you, Mr. Chair. Messaging is important, and the Fraudulent Joinder Prevention Act of 2015 could also be called the Corporate Defendant Forum Shopping Act, because in actuality that's what it facilitates. If enacted, the bill would upend a century of legal doctrine governing how a federal court decides whether to remand a case that was removed by an out-of-state defendant on diversity grounds, and where there's also at least one in-state defendant in the case. Under this doctrine, known as the Fraudulent Joinder Doctrine, a federal court retains jurisdiction over a case lacking complete diversity only when there is no reasonable basis for the plaintiff's claim against the in-state defendant. There is simply no evidence that federal courts applying current law have failed to properly address fraudulent joinders. What H.R. 3624's proponents really object to is the fact that current law generally favors remand of cases raising state law issues to state courts. This is in keeping with the long-standing judicial recognition that constitutionally federal courts are courts of limited jurisdiction and should therefore construe removal statutes strictly and narrowly. Tellingly, the Supreme Court has not seen it necessary to change the Fraudulent Joinder Doctrine or ever stated any concern about the way federal courts have been applying that doctrine. In short, after a century of application, the Court has not deemed it necessary to alter the way federal courts deal with fraudulent joinder. In addition to being unnecessary, the bill increases the complexity and costs surrounding remand motions. The bill effectively requires litigation on the merits at the nation stage of the case, potentially dissuading plaintiffs from pursuing meritorious claims. H.R. 3624 requires the application of vague and undefined standards, which invites further litigation over the meaning and scope of those standards. What constitutes a, quote, plausible, unquote, claim is not self-evident. We know this because courts have been struggling to apply the plausibility standard with respect to pleadings in federal court after the Supreme Court's Ashcroft versus Iqbal decision applied such a standard to pleadings under the Rules of Civil Procedure, number 8. That decision has produced a substantial amount of litigation that's led to increased uncertainty, complexity, and litigation costs. There's no reason to think that the same thing will not happen once such a, quote, plausibility, unquote, standard is imported into the remand context, as H.R. 3624 would do. Similarly, the bill's required inquiry into plaintiff's subjective good faith intention will result in increased litigation as well. The bill does not define good faith intention. It's not used otherwise in Title 28. The increase in cost and complexity would not only drain limited resources of plaintiffs, but also burden the already strained federal judicial resources. Finally, this bill violates states' rights by denying state courts the ability to shape state law. State courts are the final authorities on state procedural and substantive law, and state law claims ought to be left to state courts except in the narrowest circumstances. This bill would further deny state courts that authority by making it easier for federal courts to retain jurisdiction where only state law claims are at issue and possibly imposing new heightened pleading standards on state courts. H.R. 3624 represents just the latest in a long line of attempts to deny plaintiffs access to state courts and to extend inappropriately the reach of federal courts into state law matters. Ironically, on so many matters here, we hear about states' rights, and we hear from the other side about the rights of each state to make their decisions. But when it comes time to plaintiffs, we don't care about states' rights. We care about defendants, and that's unfortunate. But it is the hobgoblin with simple minds, I guess. But anyway, with reasons stated, I oppose the bill.